I'm joined today by Shawn Meehan, a former elector for President Trump in the 2020 presidential election from the state of Nevada, as well as a Master Sergeant in the U.S. Air Force retired, and now the founder of Guard the Constitution, an organization dedicated to putting we back in we the people and educating citizens about the importance of the Constitution and defending it from subversion. Shawn, thank you for joining us today.
Thank you for having me, Christian. I appreciate the invite.
Absolutely. So one of the main things that Guard the Constitution is fighting against are attempts to call a convention under Article 5 of the Constitution. Now, for those that are watching who may not be fully versed on Article 5, could you just briefly recap what Article 5 is and explain what all the noise, so to speak, about it is?
Sure. Article 5 is in our Constitution, one of the 7 articles that describes how the Constitution is to be amended. On September 15th, 1787, at the Constitutional Convention in Philadelphia, George Mason stood up and realized that there was no way for the states to object for needed amendments if, by chance, the government, as they thought, would become tyrannical. Here's where the problem between convention of states, the other convention advocates, and groups like myself and the John Birch Society, where we have our problem, is they distort the purpose of amendments. And it was very clearly stated by several of the founders that they knew the document, while it was inspired, would contain defects. And they believe that the Article 5 convention option was put in there to restrain the federal government. Well, that's a complete misunderstanding, because the Constitution itself is designed to do that.
So the purpose of Article 5, then, according to the founders, was to remedy any kind of problems with the structures of government, then, the Constitution itself. If there was to be found a flaw in the future in the Constitution, then this is the reason why we would maybe need to perhaps pass amendments in the future.
Absolutely. Some of your best, operators manuals for aircraft, anything like that, under application and use, it's going to always reveal, minor deficiencies. That's what the intent of the founders was. And in fact, George Mason himself stated something to that effect early on in the convention on June 11th, if people want to look at Madison's notes of the convention.
Speaking of Mark Meckler, it was about 2 years ago, on January 11th of 2020, that you posted a video challenging Mark Meckler, the president of the organization Convention of States, to debate both you and constitutional scholar Robert Brown at the Idaho legislature on February 6th of that year. Now, Mr. Meckler did not accept your invitation for a spirited debate. Why do you believe that is?
Well, they state that it's because all the debates have already been had and whatnot, but I think it simply is because Robert and myself have, without question, credible original source references that destroy his argument. And anecdotally, to the point, back when I really got involved in this in 2014, the Carson City Republican Central Committee invited me to present on it. 2 days later, I was told that Mark Meckler himself would be my opponent. Being new on this issue, I was a little nervous, but I said, well, you got to dive in. 2 days after that, I was told that he would not attend and they would send their local person. And the county representative in my county for Convention of States, who's no longer a rep, actually told me, God bless her for her integrity, that she was told that they are not to engage me publicly at all in any capacity. Well, to me, that sounds like that could be an admission that they don't like the credible facts that are presented, and much like Robert also presents.
So essentially, it's COS standing orders to their employees and their volunteers and chapter captains, whatever they call them, chapter leaders, captains, to not publicly debate either you or Robert Brown. That's very interesting. So you don't expect.
And it's interesting to also point out that Mark Meckler was on local media in Boise, and I actually called into the show from my home in Nevada, and he was saying that Robert Brown and I actually said on the air, Robert Brown and I go around the country lying, and he has no need to debate liars. So Robert and I, our shtick was kind of, if we're lying, it should be very easy to come onto a forum that we coordinated, planned, and were paying for and destroy us with facts. We welcomed the challenge, and you know how it worked out. He refused to show up.
Well, the truth will set you free. So if Meckler is saying the truth, and if you and Robert Brown are liars, then that should be easy for him to expose. But I guess he fears the actual truth, then, unfortunately.
Yes, sir.
So in your video challenging Meckler to a debate, you also said that he's made some rather incendiary accusations in public. Could you say what some of those accusations that he's made are?
Well,
Besides
the one
calling
I
you
just
and Robert Brown a liar, of course.
Well, the one, yeah, that's the one that I've heard this in a few different areas that he says this. What's also interesting is I've had a few friends that have reached out to me that they reached out. God bless them. They didn't want to assume anything. They wanted the facts, so they got the side from me that's against the con, and then they reached out to Convention of States and said, "Hey, we've heard about this guy." Shawn Meehan, what do you think? Rather than Convention of States writing back and saying, here's our point of view, why we don't agree with them or whatever, they offered ridicule and an email response that went to try to defame my character instead of my information. We also understand, what's his name? David, is it Schwimmer or Schneider? He's a regional director in the middle part of the country for Convention of States. He goes all over social media being just short of vulgar and making it about personal attacks and not wanting to talk about the content of the issue. And I think that's very revealing. People with good arguments don't make personal attacks.
Absolutely. Those are excellent points. Mark Meckler, as well as others like Michael Ferris and Professor Lawrence Lessig, have also contended that what they're proposing is a convention of states and not a constitutional convention. So there seems to be some confusion about these two terms. Could you clarify for us? Are they right, or are the two actually entirely different, or is that not the case?
There was a Supreme Court opinion years ago where it tangentially involved the issue, and they referenced the founding of the country and the Constitution, and they actually called the Article 5 convention a convention of states. And the Convention of States organization actually uses this themselves, I think, to mislead people. If you look at the text of Article 5 itself, and like Justice Scalia taught us, it was designed to be read by the average person. It's really quite simple. The convention option available in Article 5 is a convention for proposing amendments. It is the term Convention of States is not in the Constitution anywhere. And I think it's a doing business name for what their actual registered entity name is, called the John Hancock Committee for the States in Texas. They're an LLC. But the Convention of States is very, very misleading to legislators because, as you know, Christian, what they're trying to do is sell the persona that the states will control any convention that happens. And we know from the 1787 convention that simply isn't the case.
As a matter of fact, that leads me right to my next question, that there seems to be some confusion about whether the states or Congress would control the convention going into it, and then also the question of who controls the convention once it's convened. Of course, as you pointed out, Meckler and COS, they contend that the states will control the process from beginning to end. Why is that not the case?
Well, here's an interesting broad theme. But for the issue of having a convention, I would argue that the Convention of States supporters, people that support what I do, people that support what the John Birch Society does, would all agree basically on what the intent of the Constitution was, and the intent. The problem here is, if we look at Article 6, like Robert teaches of the Constitution is the supreme law of the land. On Convention of States and our folks, we agree we are not following the Constitution. Again, the supreme law of the land. So in a broad conceptual format, how can you tell me that for over 200 years we're not following the Constitution, the supreme law of the land, but this convention and the rules will be followed, when we have the Congressional Research Service report from a few years ago that shows the history? Congress themselves 41 times have asserted bills that say they will control a convention. Specifically, in 1973, the Federal Convention Act was passed unanimously by the U.S. Senate, was not passed in the House because the priority fell back and they weren't pushing for a convention as much. But they clearly said that we're not just here to rent the hall, turn the lights on, and buy the hot dogs. They were going to define who can be delegates and all kinds of things like that. So, and then the ironic thing is, we also all agree that the Supreme Court has been coloring outside their lines. They've become a political organization. They are not performing the mission defined in Federalist 78 as the founders intended, to offer constitutional opinions. We agree that they're a problem, but the attorney for Convention of States, in a classroom briefing in Boise a couple of years back, I actually heard him say that, well, if the convention exceeds its authority, we'll go ahead and litigate. You're telling me that you agree the courts are the problem. You want to have constitutional amendments to rein the court and their rulings in, but then you're saying you're going to go to the court to fix the problem and override the government and put it back in the box it came in. This is circular logic, convoluted thinking. And to say that the Constitution's not being followed, but you have to amend it to clarify it, is utterly ridiculous, because if you know it's not being followed, then you know it doesn't need clarified.
That's absolutely right. And if they're not following the Constitution now, as it is, why would they follow it when it's amended? In fact, Congressman Thomas Massie tweeted that back in 2018, and it still is a valid question that COS has yet to answer.
Yeah, I think COS is getting lost. Robert Brown and I actually were on the phone yesterday discussing an interesting observation. They claim 5 million supporters, which, if you look at Robert's program that he did, The Power of 500 in Montana, when he was a JBS area coordinator, you could argue that COS has 15 times the people needed across the country to get into congressional districts and press for obedience to the Constitution right now. So I think it's absolutely fair to say Mark Meckler and his constituents have no intent of enforcing the Constitution. The only thing they want is to change it.
Absolutely. And of course, I like the point you brought up with regards to the if the convention somehow exceeded its authority, that they would litigate when it's ironically, you have Meckler and COS advocates saying that the Constitution that the founders gave us is not the current Constitution, that the current Constitution, in fact, is thousands of pages made up of constitutional law. And Meckler likes to hold up his copy of constitutional law textbook that has all the case laws interpreting the Constitution for the past 200 plus years. So Meckler says that that's the current Constitution. So why would he rely on that Constitution, should he have to, in case the convention doesn't go the way he claims it's supposed to go? That's a very valid point.
Meckler has given us a gift recently. He writes on a couple other blogs. He writes political articles, and he wrote a very compelling argument recently about how it's time for us to rise up. And he makes an excellent argument for nullification, which is incredibly hypocritical, because, as you well know, Ferris, Meckler, and all those, Nadelson, they all say, well, nullification is unconstitutional. But yet we look, and and I'm not in favor of use of marijuana, but the point is, states are finally saying, the federal government, you have no authority under the Constitution to tell us what we're going to put into our body or not. Robert speaks often about the Real ID Act and how states pushed back, and I think it's going on 10 years or more, that the government is like, okay, we're going to pull this back. We're not going to enforce it. I believe it was last year, Governor Kristi Noem in South Dakota it was a smaller tranche, but it was federal COVID money that was unconstitutional. And she said, we're not going to accept that. And there are other instances around the country. Texas is amazing right now with the lockdown rules, the mandatory vaccination rules, things like that. They are standing up through their governor and attorney general and saying no. And Christian, I think what's incredible about this is it's fueling the conversation, and people are opening up their pocket constitutions and saying, maybe I don't know what this says. Maybe I don't know what it was meant to say. And they're letting that precedent and the misapplication and contorting of it over those hundreds of years. They're saying that is actually not what it's supposed to be. We don't need to amend it. We just need to read it. And I think that's an encouraging movement, that interviews like this and the other work that JBS and other groups do is extremely important. We cannot yield the ground to the fact that the Constitution has been amended 27 times. The Supreme Court is not empowered to amend it. And when they pass unconstitutional opinions, I would argue under Article 6, anybody that takes an oath of office has a duty to disobey unconstitutional opinions.
Absolutely, and you yourself have taken such an oath when you were in the United States Air Force, so you know the gravity and importance of that oath.
And I think there's members in the military right now that have had the courage to stand up and refuse the shot. You know, I had the anthrax shot pressed on me when I was on active duty, and I resisted and I resisted. I finally took it. But I know people that were severely injured, and the process was not under the law. Even the unconstitutional law was not properly followed back then. We're now starting to see the U.S. Navy SEALs just the other day that appealed this. The court issued a stay. We're going to take a look at this. You can't, the brand new defense bill that was just signed, I believe, the other day, there's actually a provision that you cannot kick people out of the military while this is being done. We have just seen that the military, that I'm proud of our military, but I'm also disgusted with its leadership, is they have come out and said there's been thousands of religious exemptions applied for by members of the military under the free exercise clause of the First Amendment. They've been blanketedly denied. And the DOD has their own policy that says they must be processed and considered individually. We have got to stop these leftists that are getting into leadership in our military, our government. And I'm glad that my brothers and sisters in the military are standing up, becoming advised of what their rights actually are, not rumors, but what the rights are. And they're pushing back. And as you know, Christian, that's what the founders taught us to do. Jefferson talked extensively about the people of this country being educated and then pushing back once they're educated. And that needs to be our focus.
You know, back in October, President Biden issued an executive order that would be implemented through OSHA, requiring companies of 100 or more employees to have their employees be fully vaccinated or face heavy fines for each individual, quote, violation of that order. Now, some states, such as Texas, we've seen them push back with their own executive orders. Governor Abbott, saying companies here cannot have such a mandate for employees of 100 or more. And when asked about this, the White House press secretary said, "We know that federal law overrides state law." Now, she was referring to what many call the supremacy clause based in Article 6 of the Constitution. Was she right and correct in saying that federal law overrides state law? And does her explanation even apply, even if she is right?
Federal law that is properly derived from a delegated enumerated power in the Constitution does override state law where it conflicts. But she was offering a conclusion that has not been made yet. It's that simple. And I would argue, you know, we're taught, and this is how the left keeps people on the right down, is they say, well, don't have your conflict, you know, go read your Bible quietly in the garage, but don't, you know, start an argument or discussion. Why can't the Senate get along? I don't think any of the founders, they abhorred violence, but they taught us that you know, ambition and avarice was designed to oppose ambition and avarice. The state of Texas standing up against the federal government and saying, no, you must hear our side of the discussion, and then we'll decide what the Constitution said and meant and what we're going to do. That's by design. A people that cower and go away quickly, as we look at the history of the world, will very quickly lose what liberty they have. We must agree, disagree, debate. Some of my best friends are people that I started off disagreeing with, and I learned from them and they learned from me.
Yeah, you said something very interesting just a moment ago. You said that federal laws, when they are in accordance to the Constitution, when they're crafted correctly, abiding by the Constitution, they do override state laws when there's a conflict. But what about in cases when you have laws that do not abide by federal laws that don't abide by the Constitution. Congress passes a law clearly unconstitutional. The president of the same party, let's say Obama or Biden, signs that bill or legislation into law, and now it's the so-called law of the land because the federal government has passed it. Do states have a moral obligation at that point to refuse to obey that law, or are they duty bound because the federal government has acted?
I would argue that if they sign a law that is not based in a delegated authority in the Constitution, that the states don't just have an opportunity, but I would argue they, to use your phrase, they are duty bound to disobey, to put the creature back in the box that it came in. And
how would they do that?
Well, they did, like I said, the thing with Kristi Noem, they refused to take the money. They go ahead and legalize marijuana. They do their own thing. They stand up. The current situation we are seeing with the mask mandates and things like this, when President Trump was in office, he argued from the podium about a national COVID policy. And I understood where he was coming from. While it probably wasn't constitutional, but was really illuminating and great was, like Governor DeSantis and other governors, they said, no, we're going to do what we're going to do. And now we have the data to show that was the right approach. But it's very interesting that the lawyers used Marbury v. Madison, a very early Supreme Court case, where it basically said the right of judicial review or the final say is up to our Supreme Court, which no founder ever said. In fact, in Federalist 78, it's very clear the Supreme Court is the weakest branch of government. They are not co-equal. But what happens is, if you read further, Marbury v. Madison, and I forget the quote, but it also talks about how laws that are passed that don't have a constitutional basis are no laws at all and are to be ignored.
Bam. So wouldn't that then negate the need for an Article 5 convention then?
Absolutely, unless you were one of the Koch brothers or one of these other wealthy people, the Texas Policy Institute, I think they're called, and all these other groups that support an Article 5 con. You have to have it for whatever means you have, but it's not what's needed. And I learned that very clearly when Robert Kelly, the attorney for Convention of States, gave a presentation in Boise, Idaho a couple of years ago. And I was just sitting in the back. He didn't know who I was. Yeah, I was collecting intelligence. And a gentleman in the office or the room after the class said, why do you want to amend the Constitution if we don't obey it as it is now? And he gave some baloney answer. Well, if it doesn't work, we'll go to the courts and it'll require millions of activists. And this nice man just stood up and said,
sounds like he needs it sounds like he needs the John Birch Society and guard the Constitution at that point.
Yeah, he stood up and said, why do we need to amend it? Let's just take the activists. We'll agree on that point and let's get out and enforce it. And of course, the attorney for Convention of States was rather upset and he had nothing further to say on the topic.
Well, there you go. So for those that are watching and that are concerned and want to be active with any potential Article 5 conventions that could be being introduced in their state legislature, where would you recommend them to go? Now, your organization has a website, correct? Guard the Constitution?
Yes, guardtheconstitution.com. We're redoing some of the structure, but we have a contact page there. I would also recommend, if you go to your John Birch Society website, you have a great page that's focused on some of various history and ways you can be active as a member, and resources there. And you can also Google Eagle Forum. Phyllis Schlafly's old group did some great work, and they've got a good resource page on Article 5. And I just want to say thank you to my friends at the John Birch Society. I'm not a member, but they've always been very receptive and respectful to working with us. Robert Brown was one of my early mentors on Article 5, and I was honored to present with him to the Idaho legislature. And I think it's great that these various groups that believe, even a few Democrat groups that are against the con, we might not agree with them on anything else, but where it's needed, we can come together and push back. And it's been several years since we've had a thing pass. And it's important to point out that ALEC themselves came out in South Carolina last year, and one of their attorneys testified that they are now aggressively pursuing a procedure to aggregate together all pending Article 5 calls, regardless of the limits and regardless of the topic. So Mark Meckler and any of his people that purport to say to a legislator, you can be safe, we'll control the convention, he's absolutely misspeaking, because there's an article that was written by a man in Georgia that was, I believe, a state director for COS, who talked about, I think his first name was Paul, he talked about that was the process COS had to get on board with, stop emphasizing the quote limitations on a convention and put them all together. And I believe they're only a few states away if you do that. So that's dangerous.
So this is essentially where you foresee the convention movement going. They're going to aggregate COS, BBA, Wolfpack, even on the left, and some other con calls that people have probably forgot about from decades ago, so maybe even centuries ago, like the New York application for a convention for a Bill of Rights. Put those all together and say, here, we've got our plus 34 states needed here. Time to call the convention. That's very dangerous. Of course, yes, something more you want to say?
Yes, Christian, and we need to call out to folks and remind them. Let's say, for example, the argument that 1787 was a runaway, which we all know it was, and we can document. Let's say that isn't sold to people that we're talking to about this. Fine. Let's say we're going to have our 34, we're going to have a convention, some proposed amendments are going to come out. Congress will decide whether it's state legislatures or state conventions that ratify with 38 states. And they say, but that'll be good because, you know, it's a huge bar and no bad amendments will come out. Well, but yet advocates for a convention and against it, many of us agree that we want to get rid of the 16th and 17th amendments. They were properly ratified. How can you possibly say nothing bad will come out of it? And then, like I said, you always circle back to the argument. It's very simple. Justice Scalia was very clear. It was designed to be read in the plain text for the people. Requires a little bit of effort and learning with the tools that the organizations have available. But the meaning and intent behind the Constitution is very clear. And if we started following it, there's audits that show a 70 to 80% reduction in the federal budget that would suddenly make projecting paying off the national debt into out years. It would still be a long, multi-decade process, but it would suddenly look possible. And our economy would become more vibrant. Freedom and liberty would start to grow again. So I could go on and talk, but I'll just say it with this is, we don't want to wheel our Constitution into the operating room for an unnecessary elective procedure. Do not put it into the wood chipper. Defend it, don't amend it.
Well said. Thank you so much, Shawn Meehan with Guard the Constitution, and the website again is guardtheconstitution.com. Thank you so much, Shawn. Take care, and God bless you.
God bless, Christian. Thank you for what you and JBS does, and thank you for the opportunity to be interviewed.